I think it's about time. We'll get going. There's maybe, a minute or so. People may start coming in. But who's here? We were just talking just a minute ago. So who's been here for like all 4 days and did the workshops and everything? Yeah. So, right, we were just saying, your brains are probably starting to reach capacity. And so thank you for being up and being here this morning. 4 days is a long time to do a lot of learning, right? So, my name's Jeff Strauss. I'm from St. Louis, Missouri. So fortunately I'm speaking today and not yesterday because my Blues played a double overtime game the night I got here, and yesterday would have been rough. But among the various things I do, and I am a technologist, I am a developer, software architect, technology advisor, but also I'm a lawyer. I don't practice law. I used to in a past life. It's been 12, 13 years now since I was fully engaged in the full-time practice of law. But I am licensed. I sat for the bar in 2004 in Missouri. I'm not a Minnesota lawyer. I'm not a European Union lawyer, right? But a lot of the things we're going to be talking about today are either legal concepts that are universal, or things around intellectual property are frequently federal law issues, which means that the fact that I'm a Missouri licensed attorney and we're talking about things that were at a conference in Minnesota doesn't matter. These are federal concerns. Now, if you've seen any of my lawyer talks before, you know like the next slide, and if you haven't, that's okay. So like hashtag I'm not your lawyer. That's really important for a couple of reasons. First of all, I don't want to be disbarred. Second of all, we're not talking about legal advice. This isn't legal advice. I'm not your attorney. The reason that matters is because attorneys are actually important. If you are dealing with intellectual property concerns, you probably need to have an attorney. You want to have an attorney. You want to love your attorney, but your lawyer knows your situation, knows the details about you and what you're trying to achieve. I can't possibly know that standing up here talking in a room. So this isn't legal advice, and I'm not your lawyer. Also, I'm not a patent lawyer. We're going to be talking about patents. I know a fair bit about them, but I'm not a patent attorney. That's kind of an interesting thing because in the US, when you complete law school and you go and you sit and you take the bar exam and you pass and you go and you take an oath in your state capitol and get sworn in as an attorney, the next day, in theory, I could defend someone in like a capital murder trial. I'm licensed to do that. I shouldn't. I can. However, I can't defend a patent before the U.S. Patent and Trademark Office. That is the one and only thing where you need to have a separate license because at the time I took the bar exam, I did not have an engineering degree and I did not have years of requisite experience in the art and some sort of technical background, which means I was not eligible at that time to sit for the patent bar, and you have to actually take a different exam. I don't know why it has to be that way, but not for, say, criminal trials, but that's how it is. Now, I want to sort of start by giving some backgrounds, some basics, some definitions, because this is not the kind of thing I'm assuming that most of you are thinking about every day. We're developers, we're software people, we're technical people, designers, QAs, what have you, but we're not usually thinking about the law on a day in, day out basis. And so there are some terms and things I just want us to sort of think about before we get into the specifics of different types of intellectual property. So first and foremost, what is this thing? What is intellectual property? At its core. Anyone want to take a stab at it? It's okay if not. Okay. Stuff you thought of. Yeah, no, that's good. Stuff you thought of and you created. So that's an important component. So what I'm going to do first is we're going to actually take a step further back from that. And I'm going to ask you this question. What's property? It's not necessarily what you think. See, property is a legal construct. This is a thing. This is a water bottle. It's just a thing. It's not property. What makes it property is the fact that it's my thing. Right? What makes something property is about relationships. Property is about the relationship between a thing and an individual. In this case, there's a water bottle and there's Jeff Strauss, and the relationship between me and that bottle is what makes it an article of personal property. And what defines property in that legal way, usually we think about things as sort of a collection of rights and obligations that define the relationship between me and this thing. Let's talk about that for a second. Rights and obligations. This is not even an intellectual property issue. This is just property. The idea of rights comes actually out of real property law, real estate law originally. And a lot of times in real estate law, which is very old law that's been around in both common law and statutory law in Europe, the United States for centuries. We think about rights and we think about, people often talk about the bundle of rights. And what that means is that there are these individual things that identify that make that thing mine. First of all, and I think the one that's most obvious, is I have the right of possession. It's my bottle. I have it. I want to have it and hold it forever and ever. It's mine. And I have the right to possess it because I own it. It's my bottle. I also have the right to control its use. So not only can I say it's a bottle, I know it's a water bottle because we defined it as a water bottle and that's what's in it right now, but it's mine. If I want to put juice in it, it's plastic, I probably shouldn't try to turn it into a decorative candle, it'll melt. But if it were a glass bottle or something, I could decide I want to use it for decorative purposes. I can control the way it's used. I have the right of control over this thing. Exclusion. It's mine. I own it. I have it. Denny, I'm sorry, you can't have it. Right? Maybe Jay can have it. That's up to me. Right? I have the right to share and use it with whomever I want, but I also have the right to exclude someone else from using and accessing my property. Then we have enjoyment, which is similar to control, but it says regardless of how I'm governing control of this thing, I have the right to enjoy my property in whatever way I see fit. And lastly, the right of disposition. Disposition is a fancy way of like how to get rid of something. So sale, transfer, throw it in the trash, ideally recycle it, what have you, but I have the right to decide how I dispose of that thing, when, where, and how. So those are my rights. That's the bundle of rights that define my property, the relationship between me and the bottle. But there's also obligations. It's not carte blanche. So, first of all, if I decide what I want to put in that bottle is, super hot liquid, and I want to splash it on somebody or something that's explosive or whatever, and I'm trying to hurt people, that's illegal. The fact that I have the right of control and enjoyment of my property doesn't mean I can do something that is harmful or unlawful. So I have restrictions even on the thing that is entirely and completely mine. There's a requirement of non-interference. So I can use this property and enjoy it as I see fit so long as I'm not interfering with your use and your enjoyment of your property and your rights. If what I am doing tramples on the rights that you have with respect to something of yours, or even with respect to this item, this article, because it's possible that it could be partially my property and maybe partially one of yours as well. Real estate's actually a great example for that, apartments and things like that. And then there's simply contractual things. Even if I own it, I might sign a contract or have a license and let someone else have rights. And in doing so, I'm probably giving up some of my own in order to provide some of those rights to somebody else. So, all that being said, let's go back to this question. What's intellectual property? Well, it's all of those things. It's just property. It's all of those things, but specifically, when we talk about the thing, it's a thing that is actually the product of the human mind. That's what makes that's what distinguishes it, and nothing more. Now, we treat it differently. We have very special laws in place, very special rules and things in place to protect this. We have a lot of protections around intellectual property. Why do we do that? Well, because here's the thing. You can see this. You can see the bottle. You can see my laptop. You can see the clicker. Right? You can't see an idea. It's intangible. So because of that, we have to find ways to define what that thing is, what it looks like, and how we protect it. We also want to protect it because intellectual property laws and protections are largely about incentivizing innovation. We want people to be creative. We want to write good software. We want to build cool things. We want to invent amazing feats of engineering and medicine and science. We want to protect people's means of getting the most benefit out of that inventiveness and be incentivized to create. So we have to provide protection there. Okay? Those protections come in the form of really four major areas. The first three are more the classic traditional protected by statute type, different types of intellectual property. We have copyrights, trademarks, and patents. They are not the same thing. We're going to talk about each of them. They are all different mechanisms for protecting different types of intellectual property. And then there are trade secrets. And trade secrets are also a form of intellectual property, but as we'll see a little bit later in the talk, they can't quite be protected in the same way because by their very nature, they're secret. And when we actually go and try to protect these other things, by their nature, they are not. So we'll kind of look at that distinction in a little bit. Questions about just these general ideas, property, IP, before we get into the nitty-gritty? Cool. All right, copyright. Copyright is, I think, fairly common. It's not a thing that's obviously unique to technology. I think that it is probably, of the various forms of intellectual property, the one that is most readily understandable and recognizable to people, whether they are technologists or else, or whatever they are, because copyright is really just about protecting works of authorship. Right? When we have a copyright over a piece of intellectual property, that intellectual property is a work of authorship. For example, right, like Mr. and Mrs. Dursley of number 4 Privet Drive, we're very proud to say that they are perfectly normal, thank you very much. It's a book. I think we mostly recognize, obviously, you open a book, you go to the inside cover, you'll see all sorts of copyright stuff, the year it's published, maybe the year that it was updated, new revisions, what have you, information about the publisher. That's a copyright. But it's not just about books, works of authorship. So, what about my slides? It's a work of authorship, right? Now notice, and we'll talk about this again in a minute too, I don't have anywhere in any of these decks, not in the presenter notes and not on the slides, you don't see a copyright notice. We're going to talk about that. But this is a work of authorship. Counts. Right? What about artwork? Oil on canvas. Marc Chagall was a really twisted dude. But this is a work of art. But this work of art is also a work of authorship. It can be copyrighted, right? So what about our code? Copyright code? Absolutely. Absolutely. It's a work of authorship by the person who created it. The reason for that is because what a work of authorship really is, and what we're protecting with copyright, is the expression of ideas. Any way that you are expressing an idea. So if you're Joe Rowling and you're writing Harry Potter novels, obviously you're expressing ideas and you're telling a story. But the Chagall painting, I don't know what he's trying to express. This guy's got a head severed over here, he's got a dagger. I don't know what's going on in The Drunkard, but he's expressing ideas. Our code is doing the same thing. We're creating functionality, we're handling events, we're presenting UIs, we're doing whatever it is we do, JavaScript, which I think can basically do everything now. We're expressing ideas, and the point is it doesn't matter. It can be through any medium at all. Not just visual medium. Not just visual media. Take, audio recordings. Music, albums, they're subject to copyright. Video recordings. I own the slides. This talk's being recorded. NDC owns the video recording of the talk. And that's a work of authorship. It's still a copyrightable material, right? Who's ever heard the disclaimer? Baseball fans? Right? Any rebroadcast, reproduction, or other account of this game without express written consent of Major League Baseball is prohibited because they're protecting a video recording, right? Dance choreography, if it is sufficiently described, is copyrightable. Now, it happens automatically, which I think surprises a lot of people. And back to the point of my slides, and there's no copyright notice, that's okay. That's okay. By the fact of my having completed the work, it is subject to copyright. It's ideal if I tell you, in theory, I don't really have to. I don't have to put a notice. Right? People are used to seeing this sort of thing, right? Oh, I lied. But I don't, because I guess this is a copyright notice in my slides. I said I didn't have one. But this isn't copyright, right? I'm not copywriting the slide deck to me. But we see things like this. It's not actually necessary. If the copyright notice is missing, but somebody else has produced the work, they still own that work. Now, the reason that people do put the copyright notices in, if you open up a lot of open source libraries, not only should you see a license file, oftentimes you're going to see some sort of copyright notice somewhere in the source code. You should, ideally people put those things in there. The reason for that is because you're trying to give notice, right? It's hard for me to protect my rights if nobody knows, right? If nobody knows I wrote it. So we try to put some sort of notice. One way you can do that is through registration. So usually things like books, not only is the copyright provision or the copyright notice in that sort of inside title cover page, but oftentimes that copyright is also registered, with the government, with the Copyright Office. That does a few things for you, and there are times to do that. For one thing, it gives very adequate public notice. For another thing, if you ever find yourself in a situation in a lawsuit where you have to protect your intellectual property, you're entitled to certain statutory damages, and you're entitled to recover your attorney's fees and things like that. But also, maybe most importantly, this is like a stupid lawyer word or lawyer term, but also by registering your copyright, that registration is what's called prima facie evidence. We like Latin in lawyer land. I don't know why. But what that means is that normally if you bring suit, if I want to come and I think that you've taken my work and infringed in some way, and I try to sue you, as the accuser, by being the one who is bringing the accusation, I have a burden of proof. By having prima facie evidence, I have satisfied my burden of proof. The burden shifts to you to defend. So, that sounds great. The problem with our code, if we're writing open source, that's awesome. If we're not writing open source, the challenge is by registering your copyright, you're also registering the work. So bear that in mind, as nice as it sounds, if this is proprietary code that you don't want other people to be able to see, that's a bit of a problem. Because by registering the copyright for your code, you are now sharing that code. You've effectively open sourced it. And yeah, you may not give a license to people, but people are bad actors. So bear that in mind. So it's not always the right thing to do to register, but you can. And it's easy and it's not expensive. That's copyright. So trademarks. Questions about copyright? Yeah?
So you said not expensive. What is that?
I think in the US it's something like $35 to $55, something like that, to file an application to register with the Copyright Office. I mean, it's cheap. So in the right circumstances, it might be worth it. Other questions? Okay. Trademarks. Trademarks have nothing at all to do with any of that. Nothing to do with works, authorship, the written word, dance choreography, our code, none of that. Trademarks are about protecting identity. Think brand. Okay. We provide trademark protection because when a company or an individual is in the act of providing goods and services back into the marketplace, we want to protect the identity of that producer, that provider. We want to know, keep going back to the water bottle, we want to know that if I'm getting water, that I'm getting real Dasani water, whatever that means. But if that matters to me, I know. I see a valid protected trademark, and that tells me that I'm not just getting any old water, I'm getting the water that is provided by a company that I trust and that I know. That sense of identity is critical in the provision of goods and services, right? Because otherwise somebody else can do something sort of like what you're doing, and if they can pass off or if they can put your trademark on there, they can actually undercut you in the market and sell their poorly made goods or their poorly conceived services and actually damage your reputation, and meanwhile they profit off it. Now, this is an example of a trademark. This is the company I work for. Right, this is a trademark. You'll notice a couple things about this. First of all, there's like a logo, and there's words. But that entire thing, in its entirety, is the trademark for the company, Worldwide Technology. You can have more than one trademark. We also have this one. What we don't have is a version where the words are on top. We don't use that mark. That mark's not used in the stream of commerce, and it's not protected. Okay? We also have the version that doesn't have the words at all. But what is not a trademark, so this version is what we think is like a logo. This is a logo mark. What is not a Worldwide Technology trademark is that thing. Because I drew it yesterday with shaky hands on the trackpad on my Mac. It's a facsimile. It's a pretty cruddy one. The point is, even though it's a facsimile or a very rough approximation of our trademark, we don't use it in the provision of our goods and services. So there's no protection. There's no reason to protect it because there's no confusion when someone tries to sell our services or our hardware or our software. There's no confusion when they see that logo that that's not us. There shouldn't be. Okay? Now, sometimes you don't have a logo at all. Don't they make Dasani? They might make Dasani. So there's like a whole theme here. All right. Coca-Cola has what's really just called a word mark. It's a fancy font, but it's specifically this. Like, that's what it looks like. It's never in a different, slightly different color red. They never decide to pick like a different color font. If you work in a company, especially a bigger company that has trademarks, you may have come across this before where like your team, your company, your lawyers, your marketing team is like, nope, this is our brand guide. And only this. There's a reason for that, because if we start using something else, it's not really our mark. So it matters. What about this one? What's this for? Anyone? Right. Does it say Nike? Is there a swoosh? It's literally just a slogan. But it's a mark. They use it in connection with the sale of their goods. They use it in the stream of commerce all the time. It's one of their many, many, many trademarks. It doesn't even have to be the primary logo or the company name. It's still a valid trademark. Now again, interestingly enough, trademarks are automatic. Yes?
Are the words the trademark or the font and the words with the period at the end of the trademark?
It's all of that, right. So the question was, is it the words or is it everything about it? And it's everything about it. It's the way it is displayed and conveyed to the consumer. If I just want to have the words "just do it" in like a sales pitch and in the middle of another sentence, that's fine. I'm not bothering anything. But if it looks like that, right, the entire appearance and look of it is part of what made your brain immediately. You probably would just do it, would think about it anyway. But even if you don't really actively think about it, it's that stark black and white with the big, heavy, bold. Your brain immediately goes to Nike, right? So it is automatic. Again, like copyright. But it's automatic once you've used that trademark in the stream of commerce. So it's not enough that I had my art department design a new thing, or I hired someone, or I went to 99 Designs, or whatever, and I got or Fiverr, and I got a logo made. It's when I take that thing and I attach it to something that I am providing in the stream of commerce. Commerce, by the way, doesn't mean sale. It sounds like it does, and sounds like it should. I don't have to be selling anything or making money with it. I have to attach this mark to something I'm providing out to the public. If I'm providing for free, that's fine. My mark is still protected. Yeah, Denny.
Can you protect, for example, a hashtag? Can you say,
Oh.
I am the only one that can use beaming as believing, for example? Isn't it very
Fascinating. Because that makes me think about Jeff and John's Excellent Adventure. It's fascinating. So can you trademark a hashtag? Probably not, but it's more because you might be able to trademark the way it looks. So if you took the Dreaming is Believing hashtag on your website or on other materials and things that you do, and you design it in a certain way that you use it consistently in the right font, in the right way that's presented, and you're consistent in that way, and you're out there doing things with it in that way, then sure, but it's not because it's a hashtag, it's because now you've created a thing that is representative of your personal brand. If it's just a thing that that's on Twitter, you don't have control over the font, how it looks, where it goes, what it links to, how it's searched on. You don't really maintain control over that mark in the first place. It's just text. If anything, you could argue like copyright, but I'm sure in the terms of service for Twitter, I've never read them because I'm sure they're thousands of pages long. But in the terms, you probably don't own anything that you post. But maybe if you actually design something around it and then use that consistently. Make sense? Yeah? All right. So, yeah, Ria. That's okay. If you are consistently using it, right, in a consistent way, if it's just the name and you change what it looks like every time you put something else out, then you aren't really doing anything in a consistent way to establish a brand. If you're establishing identity around your goods, and you are putting those in the stream of commerce, you're using them and you've developed that mark, and then you see someone else who uses that exact same mark and is selling similar stuff. Now, if you're selling whatever on Etsy, jewelry, artwork, gadgets, whatever, accessories for a computer, and then somebody else is using the same mark or a very similar mark, and they're selling services or they're selling, a vacation rental, something that has nothing to do with the thing that you're engaged in the work of, then it is harder for you to establish protection because, again, it's about protecting your identity and to make sure there's no confusion around the goods and services that you provide, right, and the goods and services someone else might. Okay? So, yep. In another state?
Yeah, I guess, how, what's that?
I mean, the geography is less of a factor than it is the nature of the thing that's being offered into the stream of commerce. So if somebody is offering something similar to you, and they're, because remember, again, a lot of the stuff, especially if you register your trademark, is federal anyway. It's a national thing. It's not, some states you can also register with the state. But it's more, yeah, Jay? Oh, you have registered, right. So some places you can do that, but it's more about, is there a risk? Think about it this way. Is there a risk that someone else could piggyback on your brand and your identity to profit at your expense? That's really what it comes down to. Is someone else absconding with your brand? Or doing something in a way that it could cause confusion where you end up at an economic disadvantage because somebody else is leveraging on top of what you've already built, even if it's unintentional. Okay? Yep.
As a clarification question about what you mean by using it in commerce, you mean from a marketing perspective, or does a sale have to be associated with it?
No, sale doesn't have to be associated, right? So you're advertising for sale, right? You put it out there and you've started establishing a link between what it is that you do, or what it is that you offer, what it is that you sell, and who you are. If you've sold nothing and have just an unsuccessful business and no one wants to buy the stuff, you have still attempted, and in so doing, you've actually put it out into the stream of commerce because you're still trying to create a brand around a thing. If it takes a year, so be it. Because again, it's not about making money even, right? It's just about offering goods and services out to the public. Okay, so this wasn't on really most of these logos, right? Not even the worldwide logo. The SM, you don't see as often anymore, but you might every once in a while. It's really the same. It's a service mark. All right, so it used to be more common that you'd see trademark for somebody who's selling goods and service mark for someone who's offering services. But they're both the same thing. You can put it on your logo. It's not necessarily a bad idea to put it on your logo. It's not required. Companies like Nike generally often don't anymore. Worldwide, you noticed, doesn't. Like WWT does not. Their brand, they've deemed, is well enough known in their industry, in their sector. They're not worried about people. They assume people know the brand, and it's not required to actually put the mark on there to protect it. Now, there is still registration. I don't know what the cost is, but it's still relatively low. It's like under a couple $100, I believe, to register a trademark per mark, right? Registering does similar things. It gives you, again, certain statutory fees. It gives you a presumption of ownership, things like that. It gives you the right to bring suit in federal court. And in some places, having a registered trademark, say in the United States, can make it easier to establish and get protection in other countries, other jurisdictions outside the United States. When you register a trademark, you start seeing that little guy. It means the same thing. The R in a circle and the little TM are both for trademarks. The difference is if you have an R in a circle, it's a registered trademark. So if you create a mark for your stuff that you're selling on Etsy, but you've never registered it with the US Patent and Trademark Office, you can't use that symbol. That symbol it indicates that the trademark has actually been registered with and filed with the government. Okay? Questions about trademarks before we get into the patents? Yep. Is the R required?
If you've registered.
No. Again, facts and circumstances in terms of like whether it's a good idea or advisable to include it, to give notice, but no. Okay.
You have two companies, like you have two, like a parent and child company. Can you use that trademark for the parent as the child company? Like, say you have two entities that you do business under. Sometimes you're doing it at a higher level of your parent company, but you may also have
that don't have their own mark.
that don't have their own mark, that might use a variation of the parent mark?
Sure. I mean, it might be nice to say like a whatever company and show that mark in that way. A lot of times you'll see that with umbrella and holding companies, things like that. But yeah, you can use the mark for more than one. I mean, and again, you can have more than one mark for a company as well, right? Yep. All right, patents. Patents. Whole different ballgame. Patents are not about works of authorship, they're not about identity. Patents are about protecting inventions. Inventions, which actually, in a lot of respects, is harder to define than a work or a mark. Because what does it really mean to invent something? And at what point should we allow someone to actually have protection about the thing they've invented to profit off or benefit from that invention to the exclusion of others? Turns out there are very concrete there's answers to that. For starters, for most patents, although there are exceptions, which I'll come back to and talk about, most things, they have to be useful, the utility requirement. If I invent something new, just because I invented it, if I invented a widget that does nothing, that sits on the ground and like has no useful purpose whatsoever, I can't patent that invention. There has to be utility to it. It has to have a use. It also has to be novel and new, which seems obvious, right? But proving novelty can actually be very difficult. Proving that no one else has done or patented this thing in the past can be very difficult and time, very, very exhaustive. The other two are kind of weird. So not obvious, non-obviousness. In EU law, I know at least one of you here is not from the States. Like in EU law, it's the same concept, but they call it like the inventive step. There must be an inventive step or an element of non-obviousness. What that means is it's not enough that I created a useful new thing. I have to create a new thing that for a person having ordinary skill in the art, okay, person having ordinary skill in the art, for that individual, it cannot just be an obvious next step from the state of whatever art exists in this thing, say in this engineering field. So if you take a look at the whole picture of like where we are today in the world and someone having ordinary skill, what that means, by the way, the person having ordinary skill means someone who, take engineering, computer science, somebody who's skilled and educated, has actual real life experience in this thing, but not a genius. It's not does someone, of genius level intellect and experience, they're able to figure this out. If that person's able to figure it out, good for him. He didn't, doesn't matter. If a person of ordinary, everyday, but professional skill in this thing could have figured it out that it's the next obvious step from what we have today, it's not good enough to qualify for a patent. There has to be some spark of inventiveness beyond what's obvious. And similarly, there has to be, it has to be very well described. Has anyone ever looked at or reviewed or seen a patent like application before and looked at them? Right? Like, okay, so several of you, they can be dozens, hundreds of pages long, tons of descriptions, especially in engineering, about how we build the thing, what it works, detailed diagrams, all sorts of stuff showing exactly how this thing works. It has to be described in such a way that that same hypothetical person, this legal fiction of the person having ordinary skill in the art, would be able to take that information and be able to do the thing him or herself. If I don't describe it that well at least, then my invention is not going to qualify. It's going to be rejected when I apply for a patent. The reason for all of this is because ultimately what we're doing here is by granting a patent, we're giving a monopoly. Right? A lot of times when people get upset or worried about patents, it's because we're basically saying, you invented this thing, and for the next period of years, no one else can do it. No one else can touch it. But in order to really protect that and give that sort of protection to that invention, first off, we need to make sure it really was novel, it really was inventive, it really was something with a spark of sort of creativity, and also has to be clear that when that patent expires, other people can get engaged and do it as well. And lastly, it also has to be eligible. So some things like mathematical formulas and algorithms, surgical procedures, natural, like theoretical phenomena, natural substances, things like that are discovered, are not patentable. So certain things cannot be patented even if they satisfy all of the other requirements. Now, this is really important. To successfully file for a patent, there needs to be no prior disclosure. I have so many friends that say, I've got this idea, I think it might be worth patenting, I want to tell you about it, and the first thing I say is, shut don't tell me. I'm not your lawyer, I'm not your business partner, I'm not your spouse, I'm not someone who's protected in any sort of way, in a confidential way. Please don't tell me. I don't want to know. I don't want there to be any risk that someone will ask me if I already knew how to do this thing and had it disclosed to me prior to when the patent was filed, when the application was filed. Don't go telling all your friends about this cool thing and say, what do you think? Do you think I can patent this? Well, not anymore. Right? So don't give prior disclosure. There are exclusions, right? Things like business partners, spouses. There are people who are bound to confidentiality in one form or another. Employees who have signed, NDAs and confidentiality agreements. Okay, right? But you got to make sure that you have that all buttoned up. Your attorney. It's not automatic. So in this country, you really do need a lawyer to do this. Like, don't try to file your own patent. You can register your own copyright or trademark. You need an attorney to help you, a patent lawyer, which, remember, I'm not your lawyer, and I'm not a patent lawyer, but you go and you file with the Patent and Trademark Office. There are similar bodies in other jurisdictions in other countries around the world. And in order to do that, you not only have to not make sure you didn't disclose it, but this is a new rule. This started, I think, in 2011 in the United States, where it is the first to file, first to the courthouse steps. I invented a thing. It's awesome. I invented it like 3 years ago. I know I need to get my act together. I need to talk to an attorney. I need to figure things out. I think it's great. I want to patent it. Meanwhile, somebody else invented it last week, independently. Doesn't matter that I can prove, I can have notebooks and information, all the stuff I did, doesn't matter. Someone else goes and files the application first, I lose. First to file wins when it comes to patents. Different kinds of patents. All right, okay, so new, not obvious, descriptive, has to have a utility. It can't just be a thing on a stage that does nothing. So there are actually different kinds of patents. There's utility patents, design patents, and plant patents, which are about agriculture and botany, that not relevant to us. Is anyone here like a botanist? Okay, not relevant to us. But utility patents are really the ones, they protect the way a thing works. Protects the way that, has a utility, the way a thing works. Whereas design patents are about protecting the way an article of manufacture looks, which is kind of confusing. Look at the difference. Take a utility patent, right? Anyone want to guess what that is? I get some really interesting answers. I always like this one. Any guess? Someone's got to have a guess. An anchor for screwing it in. That's actually pretty good. No, but it's good. So this is the tight winding mechanism that Rolex developed like 70 years ago to wind their watches. That little tiny knob that makes a Rolex stay tight and stay wound. That was one set of diagrams out of many for patenting that thing, that tiny little thing. Right? But it's describing, and you can see even the detail, if you haven't looked at one of these before, you'll get pages full of this, and descriptions, information about how it works and why it works. Very detailed about the utility and the execution of this thing. Okay? It protects us against a couple of things. Patents are unique. If you have a patent on a thing, and I take it apart and I figure out how it works, even if I am brilliant and genius, I don't look at your filing and I can figure out how it works by reverse engineering the thing, it doesn't matter. I'm infringing on your intellectual property rights by doing that. If I discover it and figure it out on my own, I just happen to say I can make something like that, or I didn't even know that you did it, and I made something similar, but you've already got a patent on it, I'm protected. Right? Patents are very powerful. They're limited in term, but they're very powerful, which is why we have all these strict requirements. Right? Because we are giving someone pretty much absolute monopoly over that thing for that period of time. Now contrast that with a design patent. A design patent is still a patent. It's not a trademark. It's not a, right? Even though it'll feel like it, because it's about a physical item of manufacture. So on the one hand, you have things like this. This is also a Rolex patent, but it's a design patent. This patent has nothing to do with how it functions at all. But they also had a design patent, and every time they release a new watch, they have a design patent around the exact way that that thing is manufactured and appears. It's not a trademark. Rolex has a trademark, the little kind of crown thing, but this is about the actual physical thing that you can see and feel and hold, and you can patent the design of that thing. Or similarly, to stick with the Dasani and Coca-Cola thing, many, many moons ago, this was a patent. Now, you might argue, Or Coca-Cola might have argued once upon a time that maybe the shape of that bottle uniquely changed the way the soda flowed out of the bottle and you got to all that delicious sugariness more quickly. That would be a utility patent. This wasn't. This is a design patent. They were designing the exact structure and look of that bottle, not a trademark. Now, Coca-Cola also has trademarks around that shape where they draw it in their Coca-Cola red, and that shape of the bottle is one of their marks. But this is not about that. This is about the actual thing that you can have and hold. Okay? It's patents. How are we doing on time? Goes till 20? 11:20? Okay. So I have an entire soapbox about code and patents of software in the first place, which would have to be like a half-day rant. But oversight and trolling are kind of two different things, right? So to some extent, to the extent you can, you need to be vigilant. And you're protecting your own intellectual property. You're the one who has a cause of action. If somebody infringes your rights, you're the one who has the right to sue. The government really doesn't. You have the right to sue, and you can depend upon your accepted patent and the laws in place to protect you, right? Trolling is a whole different thing where people are actually acquiring, because you can buy and sell these things, right? Or you can buy or sell a company that holds a lot of patents. So trolls are these companies that they're acquiring these things now. They own the intellectual property rights to things they may not have ever invented, and they sit around and they are vigilant, and they're then going around and suing everyone who somehow uses the thing, and their entire means of making money is because they've acquired intellectual property rights that they want to defend. It's like a whole different thing. Oversight, the problem is what they're doing is lawful. Right? There's nothing illegal about it, even if there's something unethical. One amazing thing about the law is that what is right versus what is lawful are sometimes the same thing. Oftentimes not. Right? Even for lawyers, what is ethically allowed for me to do as an attorney is sometimes not the same as what I feel should be morally correct. Right? Yeah. Yeah, so patent searches that's part of why you get a patent lawyer. There are databases. Google has an exhaustive patent database where I don't know if it's actually patents.google.com, but they basically have a subdomain that is just that, search, and it's incredible. So you can search, but the thing is, it's a lot harder than just saying, do I see something that looks like this? There's millions of these, right? And so there are not only patent lawyers, but paralegals and professionals and engineers who work for them who do exhaustive searches, trying to actually go through and spend a lot of time and money sometimes, trying to do their very best to identify and see if anything's out there. It's hard to do as an individual. You can do a cursory search and see, is there anything that's obviously like this that matches my search terms or whatever else, but it can be very hard to find specifically without someone who's a professional who really does these things. And by the way, just because you find a patent lawyer doesn't mean it's the right patent lawyer for you. So if you find a patent lawyer who knows a whole lot about biomedical sciences and they're a biomed engineer who then became a patent attorney, and you're a software engineer or an electrical engineer, that may not be the right patent lawyer for you. That person can help you, but that person doesn't necessarily even know the right way to go about looking for those things because he doesn't have experience in the art that you are engaged in. It's an exhaustive process. Sometimes the trademark office helps you out with it, says, what about this thing right here? It's pretty rare that you submit an application for a patent and it just goes through on the first try. That doesn't mean your thing won't be approved, but you often will get questions back, say, can you explain this a little more, or how is this different from this other thing we found? Usually there's some give and take. It takes time. But the good news is if you file, at least file within a reasonable amount of time, and you file without prior disclosure, typically your patent and your protection begins from the date of application. Not date of invention, remember, but date of filing the application. So if it takes 2 years to get approved, but then it's approved, your patent is retroactive to the date that you first filed the application. Okay? Yep. Like a patent pending?
Yeah,
or
I've worked with clients who say we have a provisional patent on this. Does that mean it's actually gone through the patent office? They're like, yep, if you actually invent this thing, it's going to be good to go, or is it really just setting an earlier filing date?
If you actually go invent this thing. Right, so that's actually an issue sometimes. So the question is, what is a provisional patent and how does that come into play, or like a pending patent? So you'll sometimes get sort of conditional approval or patent pending. You can say patent pending if you apply, even if you have no indication from the Patent and Trademark Office that they're going to approve it, until such time as they don't or reject you, patent pending. And that, because again, the idea is you're giving notice, because if it is approved and accepted, and if I filed today, and next week someone else tries to do a thing that would infringe on that patent if it is later approved, that person is going to be screwed. Because my protection is going to be retroactive to the date that I filed today. And so you give notice in that way, say, provisionally, right, we have a patent pending on this thing. So it is relevant. You don't actually have the protection in quite the same way, but you're giving notice, say, we've already started this process. Yeah. All right, trade secrets. I think we're okay time-wise. Trade secrets are really different. They are a form of intellectual property. I think I said this earlier at the beginning. They're a form of intellectual property, but they're not, and there are statutes around them, but they're not protected in quite the same way. A trade secret is about basically protecting your advantage, your competitive advantage, your economic advantage. And so the trouble with that is we don't register them at all. Copyright you can choose to register or not. Trademark you can choose to register or not. Patent must be registered. A trade secret, you do not, right? Like, it's a secret. The whole point is that there is no notice. We're giving no public notice, right? What's an ideal example of a trade secret? Go back to one of the same themes we've been talking about. You would think I'm from Atlanta with all the Coca-Cola talk, and I don't even drink soda. The Coca-Cola secret formula, perfect example of a trade secret. You know, started as kind of a publicity stunt, but it's been over 100 years. And officially, according to Coca-Cola, at any given time, there are 2 employees and only 2 employees in the world who know the secret formula. Those 2 employees are not allowed to travel together contractually. If one of them dies or leaves the company, the remaining one is required to choose a successor, like immediately. And no one else knows, right? They secretly number all the ingredients they order, and the different vendors don't know, like, they protect it vigorously. It's a trade secret. And the reason for that is because they believe that provides a substantial economic advantage. Whether or not it's actually better, I don't know, they have a lot of sales. And they don't want someone else copying that formula. But if they register it, right, everyone knows. At some point, like if you try to patent this invention, this formula, this mixture of things, eventually that patent's going to expire, and then you know what's going to happen? Everyone else is going to start making Coca-Cola, like generic drugs on the market, right? So there's a few things that are required. For starters, it has to actually be secret information, okay? There has to be commercial value, economic value. It's not just enough to say, I have this secret I'm not going to tell you. I have to have reasonable belief that this secret thing I know about actually provides me a commercial or economic advantage over my competition. And I have to actually have taken steps myself to protect it, because I can't register it. I can't tell anybody about it. So we do things like all this stuff I was talking about with like the, you know, the crazy stuff with the 2 people, you know, now I think the secret formula is actually locked in a vault at like the big Coca-Cola World thing down in Georgia, right? It exists, supposedly, inside this vault. You've taken affirmative steps to protect it. You have employees, you have people who know this trade secret. Usually it's not something quite as extreme as the Coca-Cola formula, and you're going to have trade secrets that lots of people in your organization will know about. But you have to make sure that you have, it's not enough to just have hired them and have work product from them. You have to have agreements with them. If you want to protect that trade secret, there has to be some sort of an employment agreement that sets these things out, some sort of agreement in place that actually assures confidentiality and non-disclosure when that person leaves the company. You've got to protect it. And the only thing that's protected, trade secret protection is very limited. Okay? If I sit down and I have the world's greatest palate, and I just slowly take little sips of Coke, and eventually I'm like, I think I taste nutmeg, right? And start figuring things, and I figure it out. Good for me, I win. Reverse engineering is not protected. Independent discovery is not protected. All that's protected when it comes to trade secrets is misappropriation, meaning somebody who you have taken affirmative steps to protect that secret, that trade secret, goes and does something wrong with it. Okay? There's a story once of 2 very disgruntled former Coca-Cola employees who claimed that they had the secret formula, or they knew at least elements of it, and they were pissed, and they went to Pepsi. I have no idea if this is like a true story or apocryphal. I really don't know. But they went to Pepsi, and they tried to say, we've got it. We'll sell it to you. And Pepsi said, thanks, but no thanks. Companies take this stuff seriously. And yes, there's industrial espionage, but like it's a big deal. And by the way, part of the reason wasn't just out of the kindness of their heart, but if someone acquires a trade secret that is protected, that person who knowingly and willingly acquired the trade secret from the bad actor is also liable for misappropriation. So Pepsi actually says, thank you, here's $10 million, here's $10 billion, we'll take that formula over here, thank you. Now Pepsi's on the hook too. Okay? But that's the only protection you get. So how do we get rights in these things? Because all of us, what we do every day, we use this stuff, right? Like we use intellectual property of other people all the time, all day long, right? None of us, very few of us, write fully bespoke, fully custom code from scratch every single day, right? So how do we get rights in these things? Well, oftentimes, what you'll hear is someone say, oh, hey, look, I know we had this problem, but look what I found on Google. I hear that a lot. Anyone ever said that to you? Oh, I did a Google search, I found this. I know you've heard this from people before. You've probably said it before. It's okay. But you know what? There's a really good chance that that's infringement. Just because it's on the internet doesn't mean you get to use it. Sorry. Right? Like, I found it on the web. It's published, it's out there. You can read it. You can learn from it. That doesn't mean you can, like, copy and paste this thing from some dude's blog and willingly put it into your code. Okay? Now, there are exceptions to that, but it's because there are things in place, documents in place. So take like Stack Overflow, right? Yeah, oftentimes you go and we find a thing on Stack Overflow and say, that's just it. But Stack Overflow in particular is actually a safe platform because one of the things they do is by contributing, being a contributor to Stack Overflow, those contributors have already agreed to certain terms of service, including licensing the things that they put in their answers for other people's use. But if I just have my own personal blog and I don't have any sort of license or disclaimer or anything like to give those rights, if you found it on my blog, technically you shouldn't be using it. Now, infringement is not the same thing as plagiarism. So in my comment before about what is ethical, which is a legal thing, and moral, which is a philosophical thing, are not the same. Infringement is a legal construct. Plagiarism is a moral concern. Oftentimes they go hand in hand, but they don't have to. It is possible for me to take something of somebody else's, to use it, to redistribute, republish it, to rebroadcast a game of Major League Baseball, where clearly I'm giving rights. I'm not pretending that it was mine. That, right? Plagiarism is when I pass off your work as my own. It's wrong, but I'm not necessarily doing that. If I'm rebroadcasting baseball games, I haven't necessarily plagiarized Major League Baseball, but I have infringed their rights. They've expressly told me I can't do that if I don't have their consent. So I've taken their intellectual property. That's a legal problem. By the same token, I can take something that is, even if I have permission, or even if there are rights, even if there's licenses like Stack Overflow Code, but I go out there and I try to pull something like, say, this is mine, and I pass it off as my work, even if I haven't infringed, if I'm pretending that my work, or the work of somebody else's is actually mine, I've plagiarized. Okay? Now, we get around that with a few different things. The fair use doctrine is probably the most common. The fair use doctrine does not apply to patents, but it applies to copyrights and trademarks. Copyrighted material can still be used by you without permission, without consent in certain circumstances. If you're using it for research and scholarship, if you're using it for criticism or critique, for parody, even like search engine use. Right? Google doesn't go and get permission from every single publisher on the internet to have snippets of their web pages in their search results. But there are exceptions under the fair use doctrine that say you can have like certain amounts of information in there, and that's fine. You're doing it for search purposes, for research purposes. I mean, the great example of that, aside from Google, is something like Wikipedia. And you'll actually see a lot of things, if you click on individual bits of media and stuff, you'll often see things, if they're done well and done right in Wikipedia, saying why this thing, this is being reproduced, but with fair use, and here's why. Okay? Moreover, with trademarks, same sort of thing. So when you watch like a Chevy truck commercial, and they're openly showing Ford trucks on the commercial with Ford logos on them and telling you how their Chevy trucks are so much better than Ford's, do you think they went and got permission from Ford and said, hey, we're going to show your trucks in our advertising so that we can show why you guys are losers and we're so much better than you, right? They don't get permission for that, but under fair use with trademarks, not only can you have criticism and critique, but you can also use other trademarks for nominative reference to a brand or an identity or for competitive advertising. That's acceptable. So there are exceptions, even to someone who wholly owns things. What about expiration? Copyrights expire. There's been a lot of talk over the last few years about Tolkien's works and when Tolkien's works will fall into the public domain. Copyrighted material eventually does. It's not there's a whole wacky table of rules about when the thing was copyrighted in the first place and what laws applied at the time and all these things. Usually, the most common one is usually 70 years from the death of the author. But there's lots of different ways and timelines when a copyright can expire. But once it does, that intellectual property has gone to the public domain. It no longer belongs to that author or their estate or their family, and you can use it freely. Trademarks don't. Trademarks don't expire so long as the owner of that trademark is still engaged in using that mark for their goods and services in the marketplace. If you stop using it, eventually it just sort of lapses. You're not using that mark anymore. It's no longer protected over time. There's no hard and fast rule over that, about when and how, because unfortunately lawyers way too often have the answer maybe or depends or we're not sure or let us get back to you. So there's no set rule on how, but you can abandon the trademark. But as long as you're using it, it persists. And then patents, I think design patents are good for 14 years. Everyone always says 17 years on utility patents, but really I'm fairly certain that the law is still either 20 years from date of file or 17 years from date of approval, depending on which is later. And then they'll expire. Trade secrets never expire as long as you don't screw up and as long as you continue to protect them. But when they expire, you might be able to get those rights. And then there's things like assignment and lease, licensing. So take an assignment is a fancy word for transfer. All it means is transfer, sale. So when you have an assignment of a thing, you actually have a seller and a buyer. So a company that goes and acquires another company so that it can get all of its patents so that they control the market, right? You can actually assign your intellectual property rights to somebody else. Contrast that with a license, which is a partial transfer. This goes back to something I said at the very, very beginning when we were talking about what is property. We were talking about the bottle. The bottle's a terrible example for this because I'm probably not going to share property rights in my water bottle with somebody else, okay? But you can have pieces of property where you have more than one owner. Because again, ownership is just a relationship, and it's about that relationship between the individual and the thing. So when you have a license to use something, which we have all the time in code, right? Like open source, okay? We have a lessor or a licensor and a licensee. What that means is I have a thing that I created, and I'm going to give you some of my rights. I'm going to let you use it. It may be non-exclusive. It may be totally proprietary to you now for a set amount of time, whatever it is. Some of the rights that I have, I'm giving up to you, but not all. Now, you're an intellectual property owner, and so am I. I have some rights. You have some rights. All right? So when we talk about licenses, we look at things like exclusivity. So open source is a great example of that. Most open source licenses, all open source licenses, are non-exclusive licenses. So there could be, like Jimmy Bogart's here somewhere this week, and he wrote Automapper and Mediator, and I don't know how many millions of downloads those libraries have. Every one of those people get it under an open source license, and every one of those people are property owners in his creation, in his copyrighted work in some fashion. So it's so there's a question of exclusivity. Are you the only one, or does everyone get to use it? How long does it last for? What limits do I have on it, right? And then again, when you think about licensing software and code, you got to think about, is this an open source thing? Is it just for me? A lot of times with open source libraries, or Red Hat does this, and other companies do that, there's dual licensing schemes, right? So depending on how you want to use a thing, you can choose to pay for a big fancy commercial license and do certain things, or get certain proprietary or exclusive rights, or you can get more traditional open sourcey kind of rights. Maybe get it for free, but there's limitations on how you can use it and what you want to do. So when you look at other code that you use, and this is really kind of what it all comes down to for what we do on a day in and day out basis, we're using other people's intellectual property all the time. Sometimes we're buying it, but often, even when you're buying it, you're not buying it. When you go pay for a commercial license to a tool, you still haven't actually acquired the thing. What you've bought is a license to use that thing someone else created. And so you need to be thinking about how can we use it and how can we not use it. You don't want to infringe on other people's intellectual property. Similarly, when we create things every day, either for our own companies, our own products, our clients, right? We're creating intellectual property every single day. So you want to think about how do we best make sure that's protected. Do we want to give notice? Do we want to register things? Do we want to make sure we associate a mark with it? Is there something here that's patentable? I mean, the very act of writing the code is the creation of intellectual property. You've created a thing. Be aware of that. Take steps to protect it, right? Your creativity, your ingenuity is what makes what we do special and unique. Because, right, remember, the thing is the thing that's a product of the human mind. Protect it. So, ultimately, you're not all going to become lawyers, right? Like, you're not going to become lawyers. But I think it's important to think about these topics, right? It's important to know what matters, and know, when someone talks about something, or you hear an attorney, or you hear someone else in the office say something, it's important to know what these things mean. It's important to know when you need to go to legal in-house, or when you need to seek an attorney if you have your own project and you're thinking about, oh, maybe I need to actually like get a trademark for this stuff. It's important to be thinking about those things so you know who to ask and when to ask and what the right questions are, right? And if you're a company to do these things over time, like don't just walk in and say, we have to worry about all this stuff. You don't really have to worry about it that much. Not on a day in and day out basis. What you need to do is over time, develop practices that make sense. Part of that, and I say the same thing when I give a talk that's all about open source licensing, same thing here. Like it's not that I want everyone to become lawyers and become experts, but I want you to go and include your teams. I want you to make sure the people around you understand these issues as well. Because when everyone on the team understands the issues and you empower those people to go and make better decisions, it's less likely that you're going to infringe on the rights of others. It's less likely that you're going to accidentally do something that causes you or your company or your client pain down the road. It's more likely that you're going to adequately protect your own rights and protect the thing that it is that you have created. Enjoy the rest of your day. Thank you.